On behalf of the Alternative Dispute Resolution of the Intellectual Property Office of the Philippines, I'm very happy to be with you and discuss with you our IP services in IPOPHL. Okay, this is the agenda of my presentation. I would just like to discuss some features and benefits of mediation based on our operation. Then I will discuss the IPOPHL mediation services. I will give you some practical tips or best practices that we have learned in our almost 11 years of operation. Then some what our statistics and performance. Then I will just end my presentation with some examples. So at least 2 examples just to give you the advantages of mediation. Okay, first of all, I would like to give you some definitions. This concerns ADR and mediation, just for us to be in the same mindset, since I think most of our we are in different jurisdiction. So the Republic Act 9285, which is the Alternative Dispute Resolution Act of 2004, which is the main legal framework in terms of ADR in the Philippines, defines alternative dispute resolution system as a process or service, and it gives 3 important features of ADR. One is that it is as a procedure which is outside of the adjudication process or the in terms of government agency, quasi-judicial agency functions. It also provides for the third party neutral, which is not a judge of a court or an officer of a government agency. Then it provides at least some of the procedures which may fall under the ADR. This could be arbitration, mediation, conciliation, early neutral evaluation, mini trial, or any combination thereof, which is what we call a hybrid ADR process. This could be in terms of med-arb or ad-merb. Some territory has this med-arb-med procedure. So it also provides for combination thereof. Then for mediation, it defines mediation as a voluntary process. So it means that the parties we subsume to the party autonomy provision, which gives full autonomy for the parties to determine the procedure in mediation. It also provides for the third party, which is the neutral, which is the mediator, and it provides the function of the mediator, which is to facilitate communication and negotiation, and to assist the parties in reaching voluntary agreement regarding the dispute. So when we talk about mediator, then we are talking about mediation. Okay. So the general features in mediation, this is as far as the legal framework, Philippine legal framework, it's a voluntary process, which means that parties are given flexibility on how to resolve the dispute. It adheres to confidentiality of information. So the module advantage of mediation in all other forms of ADR is the confidentiality of information. So confidentiality of information shall be admissible in any adversarial proceedings, which means that any information which is provided by the parties during the mediation process cannot be it's not inadmissible when the case goes to litigation. The mediator actually this is to give the parties the environment and to negotiate freely, and not knowing that any information that we provide could be used against them or could be used by the other party when the case is not settled. The mediator may not be called to testify on or subpoenaed during when the case goes to litigation, and then the mediator may not make a report except that the mediation occurred and its outcome. So the mediator is provided some leeway in terms of also given the confidentiality requirement of the procedure. Okay. So what are the benefits of mediation in IP cases? As you know, in terms of IP, when you talk about IP cases, it involves complex laws most of the time, especially, for example, patent cases or trade secrets cases. This would involve several litigants in several territories, which involves, so there's conflicts of laws. And also at the same time, we are dealing with complex technological issues. Well, the advantage of mediation is that the parties can appoint a mediator who is knowledgeable in the specific IP regime and in the field of technology. So this is a very good advantage in terms of mediation. Many IP disputes arise from continuing relationship between parties. For example, licensee and licensor, joint ventures, co-inventorship agreements. Most of the cases would involve submission of the dispute to either which is based on contractual obligations. So mediation aims to maintain the relationship of the parties. So it gives the parties some leeway that the case will not affect the business relationship of the parties. IP disputes involve cross-border issues. So settlement may involve different jurisdiction. And in the advent of the Singapore Convention in mediation, then the outlook in terms of mediation and ADR could be conferred as of now because of the Singapore Convention. IP cases often involve complex issues. Then mediation can assist the parties in defining and narrowing the issues concerned. Actually, in mediation, the most important aspect in mediation is in defining defining the issues between the parties. The mediation may not be settled, but if the parties could define on the issue and at the same time make some they could use this in prior interaction in how to deal with similar cases between them. So patent and trade secret disputes involve substantial risk in compromising the confidential information. So this is actually true. In patent and trademark litigation, discovery is an important aspect of litigation. So the core concept of mediation is maintaining confidentiality of the proceedings. Okay. So what are the services of IPOPHL? Actually, this is the development of mediation in IPOPHL. We started our mediation service back in February 2021. And in April 2021, we also opened our arbitration service. But since 2016, we opted to redefine and to assess our arbitration because of our MOU with our partner agent organization has expired. So we will be implementing arbitration maybe in 2022. In May 2014, we opened our Wipo mediation option, which is based on an agreement with Wipo. Then in October 2018, we shifted to mandatory mediation. Mandatory mediation is a process where at least the parties are obligated to try to mediate at least once, but they are not required to settle the dispute. And at any time during the proceedings, they could opt out of the procedure. Then in 2019, we implemented mediation outside litigation. This mediation outside litigation, it's a process where the parties could have access on the mediation services of IPO, even without filing a case in IPOPHL. Then in 2022, due to the COVID-19 pandemic, we implemented online mediation. And given the success of online mediation, in 2021, just this year, we instituted online proceedings for all our services. Now, you could all you could submit documents, pay the appropriate fees, and even submit the compromise agreement online. So it's a totally online proceedings for IPOPHL mediation. So what are the coverage of mediation in IPOPHL? This could involve IP violation cases. The Bureau of Legal Affairs has original jurisdiction on for administrative complaints involving violation of IP laws. So this could be some of the cases under IPB would be infringement of trademark, infringement of patent, utility model industrial design, infringement of copyright and related rights, petition for compulsory licensing of patent, and then unfair competition. Then we also have IPC. IPC could cover opposition for application of registration of trademark, then cancellation of trademark, cancellation of patent, utility model in industrial design. Yeah, then I think that's and then yeah, I think that's more of on IPC. Then we also cover technology transfer payments, determination of technology transfer payments, terms of license involving author's rights, and all other cases which are submitted to the Office of the Director General or appealed cases are also submitted or referred to in mediation. So we have three mediation services. One is mediation, mandatory mediation. This is a pre-litigation mediation, which means that this is covered or part of the litigation process of IPOPHL. Then we have IPOPHL Wipo mediation option. This is a Wipo-based mediation, Wipo-based referral mediation. Then mediation outside litigation, or this could be sometimes called planned early dispute resolution service proceedings. Okay, so I will now discuss each and every one of these services. In mandatory mediation, just like I said, this is part of the litigation process. All cases filed for all cases are required to be referred to mediation. So in referral of mediation, only cases where the respondent submitted an answer are referred to mediation. So if the respondent failed to answer, then it's not registered, it's not filed, it's not referred to mediation, while the hearing officer will still issue a decision based on the submission of the applicant. In pre-mediation conference, we have penalty for failure of parties to appear or pay the mediation fees. The parties can be represented by counsel. So it's based on submission of the special power of attorney, secretary certificate, or board resolution. However, the most senior officer of the non-attending party is reachable, must be reachable by phone or other communication device. In the commencement of mediation, the mediation period is limited to 90 days, but the parties could extend the parties through a request. They have to make a formal request or pleading. On the outcome of mediation, the originating office will issue a decision based on compromise. So this is we are now converting the compromise agreement into a decision of which is similar to a court decisions for easy implementation in legal implementation. Then if the case is not settled, then we referred back the case for dissolution. Okay, so that's the mandatory mediation service. Then we also have the Wipo mediation option. This is based on a memorandum of understanding implemented on April 2014. So under this service, the parties has the option to refer their case to the Wipo's Arbitration and Mediation Center. I think in Southeast Asia, only Philippines and Singapore has similar memorandum of understanding for Wipo. And then the advantages for parties this is advantageous to the parties seeking related disputes in multiple jurisdictions. So they could, I think, they could refer back to the once the case is settled, then Wipo has a database which record the case, and then the parties could refer the anyone who would like to know the if such case has been settled to the arbitration mediation database. Okay. So another option for this procedure is that the parties can appoint any mediator from the Wipo panel of international mediators. Fortunately, also we have 16 mediators in IPOPHL, and all of them are also registered or part of this Wipo panel of international mediators. Then in 2021, mediation, Wipo has granted our request for the for a preferential rate. So for example, in mediation, in Wipo mediation, you have to pay the administrative cost and at the same time the mediator's fee. Wipo has waived the administrative cost, and then they lowered the mediator's fee to which is similar to the mediation fee of IPOPHL to encourage the use of this service. Okay. Then lastly, we have mediation outside litigation. It shall apply to any dispute involving or related to IP issues. So the parties are required to file a request for mediation. Then the parties can be represented by, again, this is the parties can be represented by a counsel, subject to the submission of the SPA, secretary certificate, or board resolution. And at the same time, the most senior officer of the non-attending party should be reachable by phone or any other communication device. Okay. So in mediation outside litigation, the mediation is terminated upon these three instances. One is signing of the compromise agreement, or termination of by the parties of the proceedings, or in such cases, the non-settlement of the mediation. Okay. Actually, the mediator could also recommend the termination of the mediation proceedings if and when there's the settlement or the proceedings, the settlement is very remote, but it should be this should be agreed, this should be approved by the ADR services. So non-settlement is not a bar to submit the dispute to litigation, which means that the result of the proceedings shall not be in any way inhibit the parties from filing a similar request to litigation. Then confidentiality disclosure of the proceedings is up to the parties concerned. Okay. So this is the mediation procedure. So the first step is the referral of mediation. So IPOPHL issues order of mediation. This is an order containing the date and time within which the parties shall appear in the ADR services. Where at present, this is also the time where the pre-mediation conference shall occur, and then before the date of the pre-mediation conference, the ADRS will communicate with the parties by giving them the Zoom link, and also the anything that they should and also anything that information that they should required for the pre-mediation conference. In the pre-mediation conference, which is the next step, the parties are briefed on the benefits and advantages of mediation. Also in this on this instance, they are also required to appoint the mediator who will handle the case. And also they will have to pay the mediation fees and also submit, if they are being represented by a counsel, then they have to submit the SPA, board resolution, etc. Then the parties also at this instance, the parties can request to avail of the Wipo option. So if the parties agree for the Wipo option, then we will refer their case to Wipo, and then the IPO proceedings will be suspended for the time being until such time as the proceedings in the Wipo has a result. Okay. The next step is the commencement of mediation. In these steps, the parties agree on the grounds of the process. Usually, the parties agree uh, on the date, on what on their preferred discussion, and if there's initial offer or counter offer, then this will be provided on the early part of the mediation. Then there's of course, there will be gathering of information and identifying the issues, exploring the interests of the parties, and developing option for settlement. Okay. Lastly, there could be we now go to the end results of the mediation. If the case is settled, then the parties submit the compromise agreement to the originating office for approval. In which case, the originating office will issue the decision based on the compromise. If it's not settled, then we will the ADRS will inform the originating office and return the case for dissolution. Okay. In May 4, 2020, due to the pandemic, the IPOPHL implemented an online mediation proceedings. So this is to ensure the continuity of our service. Initially, this option is optional to the parties. It's optional. The parties can still conduct the mediation face to face. But the important thing is that there's no added fees if they will be using our mediation platform. Currently, we are using Zoom mediation, Zoom meeting app, but the parties could decide on any other meeting application, that mobile application that they want. Okay. So these are just some of the best practices in mediation and IPOPHL. Actually, we put a lot of premium on the training and training of mediators. For all you know, in the Philippines, we have we have several private mediation organization who could also who conducts mediation also. Then we also have the court annex mediation. However, we think that in terms of IP cases, our mediator should be the subject matter expert in terms of substantive IP law, and also in the way we conduct our mediation proceedings. So we put a lot of premium in our trainings. So we have an accreditation system for mediators, which involves selection, and at the same time, they will have to undergo a series of training. So right now we have 16 neutrals. These are all experts. They are not part of IPOPHL, but they act as consultant. They just go to they are being paid based on the cases they handle and based on the outcome of the mediation. So IPOPHL mediators are composed of IP and legal experts and seasoned mediators in the Philippines. So we also conduct continuous training on emerging IP issues in cooperation with our local international partners such as Wipo, EU IPO, the Office of ADR, which is the main agency in terms for implementing the ADR Act of the Philippines, and other agency, other organization. Then IPO mediators are actually recognized and accredited by OADR, which is the main agency of the government that implement the ADR Act of the Philippines. Okay. So in terms of I think the advantages of IPOPHL in terms of IP mediation is the knowledge of the mediator, skills and knowledge of the mediator. So we have to maintain a high level of skills and knowledge for our mediator in order to be competitive in terms of handling IP cases. So we have an ethics and codes of conduct for mediators. So we have a code of ethical standards for IPOPHL mediators, which means that, for example, for lawyers, they have to divulge if they have handled a case, similar case, in one of the parties. Okay, so there's also a grievance for parties in mediation if the parties are not satisfied with the mediator and they think that the parties is biased to the other party or to the issue concerned, then they have a grievance mechanism for the parties. Okay, and then at the same time we have an effective case management. We have a dedicated unit managing the mediation service, which is the alternative dispute resolution services, which is a unit under the Bureau of Legal Affairs of the IPOPHL. So penalty for non-appearance is also it's also a good mechanism for the parties to really be involved in the mediation. So they have to be more involved on the proceedings, and one way is to have a non-penalty for non-appearance of the parties. But they could always request, they could always request if they are not they could not attend the proceedings. Including non-payment is also a bar for the parties. Okay, so right now we are now operating at 100% online proceedings. So the parties could file documents, they conduct the hearing online, they pay the mediation fees online, and also they could submit the compromise agreements online. Okay, this is acceptable. Then we are ISO 9001:2015 compliant. Okay, so some statistics. So prior to August 2018, this is the referral and mediated cases. So if you look at the statistics, there's a discrepancy for the referral and then the cases that undergo mediation. So that's when we implemented the mandatory mediation. So in 2018 or 2019, the mediation it's already similar to the most of the cases are that are referred are undergoes mediation proceedings. Okay, this is the acceptance rate for mediation prior to 2018. For this is our the cases. We have an average of 160 cases, referral of cases, 160 cases for yearly. So we already have 1,714 since we started mediation in 2011, and out of that we have settled 650. So right now our success rate stands at 37.9%. Okay. Okay. So just to give you an example of our cases, this is a case involving Party A, which is an international cosmetics company, versus a Party B, which is a local company and its local distributor. Apparently, the plaintiff, the international company, sued Party B for unfair competition and then requested for cancellation of industrial design. I think this is a case wherein there's a similarity on the packaging of the products. Okay, so mind you, Party A and Party B has an ongoing cases in the lower court prior to submission or referral to mediation. So they referred the case to mediation on February 2011, and the mediation proceedings started on March 2011. So by that short of time, the parties reached a settlement on June 2021. So what is the breakthrough in this case? I think one of the mediator handling the case understood that the parties has when they first met, the party A and party B has a lot of tension between them due to the similar cases that was filed in court. And at the same time, they have already undergone several mediation in the lower court, but they failed to settle the case. So what the mediator did was to conduct in the initial phase of the mediation is to conduct caucus for each party, and giving the parties time to issue or air their demands, and also to be at the same mindset as it's the mediator. And so once the parties are agreed to mediate or to meet face to face, then that's the time that the actual mediation or actual mediation started. Okay, so the parties are very happy with the proceedings in IPOPHL, that the parties agreed to include in the settlement all outstanding cases, including those pending in the lower courts. Okay, so in litigation, this is impossible to attain, because so this is actually this is an advantage for mediation, that the parties are given free rein on the mediation and how to settle the cases. So party A agreed to withdraw all its cases against party B. So in return, party B agreed to dismiss all counterclaims. Okay. So party B for the withdrawal of the case, party B settled to continue registration of its industrial design, but agreed to renew not to renew the registration once the registration is expired, expires. So party B to pull out from the market the product which are subject of the lawsuit. Okay, so in essence, the parties have agreed to discontinue to have the to satisfy the request of each party. Then another case, this involves a copyright infringement. So AAA is a CMO, collective management organization for composers, authors, and publishers. Actually, they are the biggest CMO in the Philippines. Versus Party B, which is a large cable corporation in the Philippines. So Party A sued Party B for copyright infringement for communication to the public via cable, rebroadcast, or retransmission of copyrighted musical compositions without license from AAA. So what is the breakthrough for this case? I think for this the parties in here just settling the case in IPOPHL is already an advantage for the parties, because both of them has financial capacity to elevate the case up to the Supreme Court, which if the minimum could take them around 5 to 6 years. So the parties here, or the mediators, did a good job by explaining to the parties what are the advantage in settling at IPOPHL. And at the same time, AAA, which is the CMO, agreed to lower the damages. Actually, the damages for this case actually is extravagant, but it actually AAA agreed to lower. So the cable company agreed to pay for damages for the next 5 years. Actually, the damages that they paid was the biggest for in terms of our 11 years of operation. And the more importantly is that the cable company agreed to sign a license or user agreement with the CMO for all its cable services. Actually, for the CMO, the more important thing is the signing of the license or user agreement, and not the damages that they are requesting. So by lowering the damages and agree for the cable company to just sign the license agreement, they have settled the case and actually have a meaningful mediation. Okay, thank you.